The enforcement of DIAC awards post-Decree 34 has become one of the hottest topics among arbitration professionals. In September 2021, Decree 34 dissolved the DIFC-LCIA Arbitration Center, transferring its cases to the Dubai International Arbitration Center, or DIAC. This move was intended to streamline Dubai's arbitration framework, but it brought a lot of unexpected challenges, especially around enforcement. Today, we are diving into the complexities that have emerged. First of all, a bit of background. The DIFC-LCIA operated as a hybrid institution, blending Dubai's common law, DIFC legal framework, with the London Court of International Arbitration rules. This shift has led to a lot of confusion for tribunals and arbitrators managing ongoing cases. The question of which procedural rules to apply, and without clear guidelines, legal uncertainty and delays are on the rise. Nowadays, we are starting to face the problems of enforcement. Let's break it down to the main legal and procedural challenges. The DIFC-LCIA's rules included timelines and practices such as document production, which were more aligned with international standards. DIAC, however, operates under a more civil law-oriented framework. Without a clear direction on which set of rules to apply, tribunals have been left to make judgment calls on how cases should proceed. This confusion has an impact, of course, impacts ongoing cases and could lead to delays or challenges to tribunal decisions. This we have already experienced for a number of years. Both parties end up facing increased costs, claimant and defendant, and uncertainty, of course. Another key issue is jurisdiction. The DIFC-LCIA operated under DIFC's common law system, often seen as neutral and pro-arbitration. Now that these cases fall under DIAC, governed by UAE civil law, we have a jurisdictional puzzle. Should the DIFC or UAE civil courts handle enforcement? Many parties prefer the DIFC courts for enforcement due to their speed and alignment with international standards, at least perceivably. With the merger, there is uncertainty over whether parties can still rely on DIFC courts or must now navigate UAE's onshore courts, which could have very different timelines and procedures. The transition was quick, and DIAC initially struggled to handle the sudden caseload. There were delays in appointing new arbitrators and case managers, which caused a backlog. And since many arbitrators were chosen for their expertise in the DIFC's legal system, the switch to DIAC has complicated things for then ongoing cases. In some instances, arbitrators needed to be replaced. Further, these exceptional cases disrupting the case proceedings. Practical issues have also emerged, particularly with costs and confidentiality. Cost structures between DIFC-LCIA and DIAC differ significantly, I would say, causing confusion over which fee schedule would apply. And on confidentiality, some parties worry that DIAC may not uphold the same standards that were being used under the DIFC-LCIA. Case law is currently evolving in response to these challenges. For instance, in cases dating as back as 2023, there are a number of cases highlighting jurisdictional questions when the claimant sought enforcement of a DIFC-LCIA through the DIFC Courts post-Decree 34. The DIFC Court ultimately upheld jurisdiction, which was a win for enforcement preferences. These cases underscore how important it is for parties to specify enforcement preferences in arbitration agreements, especially when institutional changes like this happen. It's not easy to anticipate, of course. Decree 34 has clearly complicated arbitration in Dubai, revealing the living, evolving nature of the legal process. From jurisdictional issues to procedural gaps, these challenges call for expert legal guidance to navigate enforcement of DIFC-LCIA awards that have shifted to DIAC. If you are dealing with the complexities of enforcing a transfer award, reach out for expert guidance to help you manage these new challenges. Until next time, keep informed and prepare.